Good morning. This is Rich Sierra. I'm president of the Florida Small Business Legal Center. This is episode number 22 of Business SOS. Today's topic is, can I afford a lawsuit? Many times when I talk to my clients, and I do quite a bit of litigation in my practice, a common question that I receive is, how much is this going to cost me? And it's a valid question. And the answer is always, it depends. So before I start, I want to invite you to participate in the show. If you have a legal question that you like for me to go over the show and answer and discuss, please send it to me at richsierra.com. Again, it's richsierra.com. If I select your question, I'll send you an autographed copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. So I'll send that to you, and I'll send you an autographed copy. The objective of the show is to really give you some information that deals with business legal problems that I encounter now in my 19th year of practice. In fact, this October, I celebrate 19 years of practicing law. So I'm very excited and very proud of that. So I've seen, in my practice, been exclusively working with small businesses. So it's very few problems that I've seen that I have not seen that deal with small businesses. For the most part, if something happens with a small business, a legal issue, I've had the opportunity to at least address it or be exposed to it. So I'll bring that wealth of experience to the show. And my objective is to give you some additional tools to recognize what I call the yellow lights that would happen in your business. You will face legal problems. You will face legal challenges. And at the very least, they'll give you that idea to when it is the time for you to consult an attorney and seek legal counsel, as opposed to doing it yourself. And many of the mistakes that I encounter in my practice with business owners is that business owners, because we are problem solvers, because we believe, and for the most part, we want to be hands-on and do our own thing, that we can solve all the problems, and myself included. So, but there's times that the problems are beyond our expertise. There are times that the problems are really over our head, and it might be worth getting the assistance that is required to solve the problem. So, and that is the objective of the book. The objective of the show is to give you that information. Hey, you're going to have challenges along the way. They will happen. So at the very least, if you recognize in a situation that you will encounter and say, you know what, maybe this time I want to call a lawyer to get that assistance to help me get out of this problem and move on. So that is the objective of the show. And we've talked about leases. We talked about what happens if you want to sell your business, you want to buy your business, what happens if you get sued, what happens if you want to sue someone. So we cover a number of topics, and we'll continue having topics every week that I believe might be of interest to you. So today I want to talk about the cost of litigation. And as I said in my book, litigation is expensive. The amount of work that we have to do as business litigation attorneys is the same whether the amount of controversy, say, is $10,000, and whether it is, say, $100,000. There's no distinction as to the court in our obligations to do the work that we have to do for you. The rules are the same. It's the Florida Rule Civil Procedure. The court might be different simply because the amount of controversy is less, but we still got to file the same motions. We still got to prepare for trial. So the type of work that we have to do does not decrease or change because the amount of controversy might be less, with the exception of small claims that have a separate set of rules. And the small claims courts are really designed to try to resolve the problem faster, simply because in Florida, the amount of controversy is $8,000. So it is really like the people's court. The judge is there, and then you go to, in Florida, you have a compulsory mediation at the pretrial conference, and the objective is to try to solve the problem, sooner rather than later, and not involve attorneys, although sometimes, or not involved, whether you involve attorneys, but not involve a long, protracted trial that is going to cost you more than the controversy itself. So the amount that you're seeking and the amount of demand they're suing you for. One of the things that I find out when I talk to business owners about lawsuits and what is involved in a lawsuit is that there is a lack of understanding or lack of knowledge about really what goes on behind the scenes in lawsuit preparation or in preparing for trial. And you don't see a trial. It's not like TV that you have something happens at the beginning of the show, 30 minutes later you're in trial. It doesn't work that way in real life. The reality is, and from the time that you file a case, from the time you actually, a trial could take between 12 and 18 months. And that's fast tracking the case because the courts are overwhelmed. An average judge might have 3,000 cases that he or she will have to manage in his or her docket. So it is not as simple as it sounds to file a lawsuit or take a case to trial from the time that you basically filed the lawsuit or you were sued and to the time that you actually have your day in court. So I've said this before in prior episodes that 80%, and this is my opinion based on my experience, 80% of litigation is procedure. And that's procedure that we go through, and there are pretrial motions that I'll go over some of them that you will see that are very common today. There's discovery. There's a lot of things that go on behind the scenes and that the attorneys are primarily responsible for. You get involved in the case that there is a discovery that we have to request documents from you, that you have to answer interrogatories on the road. If we need to get some facts from you to help you prepare the lawsuit. But for the most part, the attorneys are in charge, and attorneys have control of this process. And to you as the client, you feel somehow that you feel out of control because you said, I don't know what's happening with my case. I'm seeing all these documents that I do not understand. You're not expected to understand them because you're not an attorney. But that's basically the initial parts of a lawsuit are procedure. They're defensive motions. And I'll just give you an example. Say, a client of mine got sued. The first thing we look at when we look at a lawsuit is a breach of contract lawsuit. Very common in businesses. And so the first thing we look at the lawsuit is, okay, can we file a motion to dismiss? Is the lawsuit technically correct? And I'll tell you what that means. There are defenses that we can raise. You have to raise them at the beginning of the case. If you do not raise them at the beginning of the case with very minor exceptions, you waive those defenses. And the way you raise those defenses is through a motion to dismiss. So the first thing we look at, okay, let's look at the lawsuit, let's look at the allegations. Is there all the documents attached, for example, that they're alleging that the client breached? Is the court a correct court? Whether correct court, number one, controversy, but also it's in the correct place. Where they filed the lawsuit is in the correct county. So we look at jurisdiction, we look at venue, we look at the allegations. There's an analysis that we do as attorneys, business litigation attorneys, when we're doing the defense side, to make sure that what is called the four corners of the complaint, the lawsuit is correct. It doesn't mean that we agree with it. Clearly, we're not going to agree with it, but we want to make sure that at the very minimum, there's some technical issues here. Is it technically correct that will survive the motion to dismiss? And if it doesn't, that's our first line of defense, is to look at a motion to dismiss as a way to push back, so to speak, and begin to create that distance between what they're trying to do, which is collect money from you, and basically then begin to put that defensive barrier. If we find that there's some areas that we can actually raise that will be, for the most part, our first course of action. We'll prepare a motion to dismiss. We state the grounds that we're actually raising that, and we basically file it with the court. And then the court can decide, and we set up a hearing, and then the court will make a determination whether they agree with us or do not agree with us, and then we'll move forward. the court agrees with us for the most part, that is usually give the plaintiff is given an opportunity to amend the pleadings and file another amendment and correct the defect, if it's correctable, and file it again. So all that costs money. And it goes back to the original, the topic of today. When you talk about an average cost of an attorney, say $400 or $500 an hour for attorney's time, and then about $150 plus for paralegal time, these items can add up quickly. So the strategy, when you look at, if you're the one being sued, when you talk to an attorney, say, how much is it going to cost me? The attorney cannot tell you precisely how much it will cost you, because a lot of the work that the attorney will have to do, if we're doing defense work, is generated by the plaintiff. The plaintiff filed the lawsuit, so we have to prepare a defense. If we're not doing an answer, a dismissal, a motion to dismiss, then we're basically filing what is called an answer and affirmative defenses, in which we look at every allegation, either we admit or deny, or we say we have no knowledge, and then we prepare affirmative defenses to that pleading, and then we send it out. So that takes time to prepare. We also have discovery. Discoveries are interrogatories that are sent to you to answer under oath. Production request. Those are documents that you'll have to provide within 30 days of service to the plaintiff that your attorney has to review to make sure that they're not confidential documents, that they're relevant documents, they're documents that we don't have to object to. If they're objectionable, then we address those. They also request for admissions. They give you admissions for you to admit certain allegations, which are designed to see if they can actually, what is called, short-circuit the case through a summary judgment. And that's a different topic altogether, and I'm going to go in here in a deep dive. So a lot of the work is generated by the other side, and also there's preparation time. You're paying for the attorney's preparation on the case. The cases are very factual, and as I mentioned before, you know the facts. You know the facts of the case. We don't. We know the law. So we're trying to put the pieces together of what happened, the events that took place that led to the lawsuit in the first place. In my experience, people sue because they're either ignored or they're pissed off. That's basically my experience. Because a lot of times you have a demand letter that precedes the lawsuit. And my preference is to resolve a lawsuit at the demand letter stage and not let it escalate to a lawsuit, if it's possible. Sometimes what happens is clients receive the demand letter, and then they ignore it, or they begin to talk to the attorney directly, which is a mistake. If you have an attorney on one side, you should need to have an attorney on the other side. And they don't come to an agreement, and then the lawsuit gets filed, and that's when I get called. So the opportunities that are missed throughout the process, and the more the process escalates into a lawsuit, the more expensive it's going to get. Some of the motions that usually are filed, very common motions, and you have the motion to dismiss the lawsuit, motion to strike part of the pleading. There are also amendments to the pleading, meaning that you can amend whether it's the lawsuit, whether it's an answer. In Florida, the amendments are liberally accepted. So the court will agree to an amendment unless you abuse the privilege. But for the most part, you'll be able to amend it. And it's very common that the lawsuit that you began with, whether you're being sued or you're the one suing, the lawsuit that you started with will not be the same lawsuit that you will end up going to actual trial with, because it'll change based on the information that you received through discovery. It is very common. There's also motions to compel. Sometimes discovery is not answered properly, or people do not answer discovery, and then counsel will have to ask the court to compel the other party to answer the questions or to provide discovery, could be a deposition. So this lacks motion practice. And what goes on behind the scenes, which people don't realize, is that for us to schedule a hearing with the court, even if it's a 5-minute hearing, it takes about an hour per legal time. It sometimes takes time from the attorney as well, because the motion has to be prepared, has to be filed. Then the paralegal will have to contact opposing counsel's office and find out when do they have a hearing for the particular motion. They have to look at the court's schedule, and based on the availability of the court, say they agree on an actual date, then a notice of hearing will have to be prepared. Then that notice of hearing has to be filed. Then courtesy copies of the documents have to be uploaded to the courts, to a system that the judge has, that way he gets courtesy copies of the documents. And in some cases, some judges, based on their preference, prefer the documents to be mailed to them. So there's a lot of things that goes on just by a 5-minute hearing. And that's unfortunately costs that you as the client will have to pay for preparing for these hearings and these for the hearings with the court. In terms of the cost, what I like to do is stages of litigation. Before I do that, I want to talk about something. And I'll go over stages of litigation in a second. You will basically pay also for what is called electronic communication, and there are different categories. Basically, 99% or 90% or more of our communication is via email now. Our inbox, emails are work. So you communicate with our office via email, in some cases via text. That is time that will have to be addressed and have to be answered. You also have correspondence between our office and opposing counsel that we have to correspond with. That is actually time that you have to that spend in terms of answering those questions and basically corresponding. So that's time that you also pay for as well. There's also correspondence between our office and the court. We have to coordinate with the court system, sometimes with the judicial assistance of the judge, to find whether it's a special set hearing, whether any type of communication we got to send. All that adds up as well. And that's all behind the scenes, with the exception of communication between you and the office. You don't know what goes on behind the scenes, so to speak, in getting ready for your hearing, for your case. And there's also correspondence between our office staff. There are instructions that we provide our staff, our paralegal, our attorneys, in terms of whether reviewing a motion, whether approving a specific date for a mediation, approving a specific date for a hearing, coordinating appointments with you, the client. All that is time that is utilized for your case, and that is billable time. So you can see how this can easily add up. Let's talk about stages of litigation. So the reason I say that is because I want you to understand that a lot of cost that is involved goes behind the scenes. And it is very, very frustrating to you as the client say, why is this costing so much money? Why, it's because the amount of work that goes into in defending you, it's just preparation time. And also be able to communicate and coordinate with the opposing counsel and making sure that you have your hearing and your day in court. So it is an adversarial system. And unfortunately, you pay for the time. So I like to look at stages of litigation, and the way I look at litigation, it is a tool for negotiation. The reason we go to court in the system that we have is that if two parties have a breach of contract case or they have a dispute, if they cannot solve it themselves, the next step is they have the court system to try to solve it for them. And the court system will solve it. And there will be a winner, there will be a loser. That's the system that we're in. So the stage of litigation I look at is basically the first stage is like the pre-suit litigation stage is the one that, okay, we send demand letters to see if we can negotiate some type of agreement or begin to have a dialogue about resolving the matter. Doesn't resolve there, then the second stage is actual lawsuit. Either you get sued or you sue someone. So, and that's the second stage. Once the lawsuit is filed, there's a window opportunity before the answer is filed or the any type of response to pleading or response is filed to the lawsuit. In that window of opportunity, it is a great opportunity to negotiate a potential settlement, simply because not a lot of money, legal fees have been invested in the case, and the other side has not really invested a lot of time in preparing the defense for the lawsuit. So I look at windows to try to get it resolved. Sometimes it gets resolved at that stage, sometimes it does not. So what I try to do is give the client, okay, from this stage to this stage, this is the approximate budget that you will have to prepare for. And if it gets resolved at this stage, then we're fine. But at this point, if it doesn't get resolved at this stage, say at the stage that an answer has to be filed, we'll sit down and talk about the next stage. The next stage will be discovery. Or the next stage you'll be responding to the lawsuit, and then the discovery phase, meaning that we will send some interrogatories requests to the opposing side. We'll send requests for production of documents, and we'll send requests for admissions, and I am sure they will return the favor and send the same thing to us as well. So it's not just sending those questions, because the cases are factual. We have to basically prepare those questions based on the facts of the case. So there's preparation time to prepare for those interrogatories to make sure that they're clear, that they ask the question that you need to ask to help prepare your case, that they're not confusing, they're not ambiguous, so that way we don't get an objection, basically say that the question is not clear, please resend it. So there's preparation time to prepare the proper interrogatories. Then the interrogatories, same thing with the production request. We had to prepare the type of documents that we're seeking from the opposing side to make sure that we ask for the correct documents. And the same thing with the request for admissions. That's preparation time. Once we develop those questions that we are going to request from the other side, there's a format by which those questions need to be prepared. There's a format that we send pursuant to the rules. Once we develop those questions, then it's prepared, put together in the format that is required. Then we serve those to opposing counsel. So you get the picture here. We have not even started yet on having a trial date. We're simply preparing your case. And because it's an adversarial system, we don't know. The reality is you do not know how much it's going to cost to take the case to trial because you don't know what the other side is going to do. And for that reason, my philosophy is if you are involved in a lawsuit is to try to get out of it as soon as you can, simply because of the uncertainty of the cost of litigation, because the other side can create work for your attorney to make sure that you're spending money. I mean, litigation is a battle of resources. So one of the parties will have more resources than the other, and for the most part, and one party can actually create tremendous amount of work for the other side, and at some point, one side will run out of money, and the attorney will not be able to continue the case. So you don't want to get into that situation that you said, I cannot continue because you're already invested in the case. So when you're in the litigation, you got to say, okay, what is the objective? And I'm going to start with the end in mind. So a good question, so going into other costs that you have to look at, you'll have to look at co-reporters that you have to pay. Those are co-reporters that appear at hearings and take transcripts of your deposition. They appear at the at hearings, and it is a good policy, depending on the type of hearing, that to always have a court reporter present to take your transcript of the actual hearing to preserve the record for appeal. So an average court reporter, and again, I'm just talking from personal experience, it's about $125 an hour just to appear. And if you order the transcript, it could be $5, $6 per page. So it can add up very quickly. Process servers, you're going to file the lawsuit. You have to send it to a process server to serve the document to the party that is being sued. And that could cost between $100 and $125 per service. These are third-party vendors. They send a bill, you pay it, but I'm telling you that you will have the other vendors involved in your lawsuit that are outside of the law firm. You also have mediation. Mediator gets involved. That's a third party that does nothing to do with the lawsuit. The mediator gets hired. Could be $500, $600 an hour, depending on the cost. The mediator is split between the parties for the most part. So you got to anticipate that. There are other miscellaneous costs, like FedEx charges, postage. In the old days, they charge for long distance. I don't know if they still do. We don't. But that's, more of a preference. But there are other charges along the way that are outside, that are part of your case, that you'll have to pay for, that has nothing to do with with the attorney's time or paralegal's time. Expert witnesses, if you hire expert witnesses in your case, you got to pay for that as well. So you get the idea in how this can easily add up. An estimated litigation period and time could be between 12 to 18 months. At least I'm talking from Florida. So you have to look at that. And trial preparation. The trial preparation is key here. And if a case is certain to go to trial because all the efforts to settle have been exhausted, so at that point, the attorney will have to basically shift the focus on you and your case, which inevitably the attorney will spend more time in your case than other cases, so your billing was going to be significantly higher than in the initial months. In the initial months, there's a lot of, you work the pleadings, you work the defenses, but you don't have to spend an entire week preparing for trial. Whereas in the case of that you're going to go for trial in 3 weeks, you're basically completely close your calendar and your case becomes the focus, and you're talking about spending every single day preparing for your trial. That's going to be significantly higher. And at that point, the attorney will tell you, okay, this is when I'm going to anticipate the time that I will be working on your case exclusively. Therefore, I need certain amount to put in my trust account to cover those expenses. So you got to talk about that with your attorney beforehand and say, listen, if we go to trial, what is it going to cost me? And then you're talking about going to trial. Going to trial, the attorney cannot do anything else except work on your case. He or she will be at court the entire day. So that's going to be paid by the hour or by the day, depending how you work that out with the attorney, plus the paralegal that will probably be there assisting him or her. Plus, in some cases, you have, depending on the case, you have 2 attorneys to prepare to help you with the trial. So the stages right now, you have the beginning stage, which is the pre-suit stage. Then you have the one that you file, the window between filing a response. You file the lawsuit, filing a response. You have the discovery phase where you issue subpoenas for deposition. That costs money. You got to use a process server to send it. The discovery phase that you actually spend time reviewing documents, and that's attorney's time, reviewing, cataloging documents. You also have to look at whether or not you have to file a motion to compel discovery, simply because in many cases the answers are not answered fully, the questions are not answered fully, but also the discovery is not produced fully. So there's sometimes hearings or objected to. So sometimes you have hearings with the court to kind of resolve that difference, but that in itself can add up. So the way I do it, I'm developing this litigation budget worksheet It is not finalized, so I'm not going to make it public yet. But one of the things that I do is basically I try to do an estimated amount of time per month that I'll spend in the case. It could be 10 hours a month, 15 hours a month, depending on the case. It is estimated because at the beginning, you're not going to spend 40 hours a week in one case. And again, depending on the case, but for the most part, small business type of litigation, you're not going to. Because there's some windows that you have to wait. You do discovery, you got to wait 30 days. So you wait. So at that time, there's really not much to do except wait. But then you have to look at the documents. That takes time. So say, okay, I'm going to spend maybe 10 hours a month for your case before I go to calendar call. So it gives you an idea. My paralegal is going to spend another 10 hours per month in your case. This coordinating hearings, communicating with you. So I like to do it that way just to give you an idea. If we have to do trial preparation, then I'll basically say, okay, we're going to spend 4 days on trial preparation exclusively. This is the cost. And if we go to trial, this is the cost. So you can basically do the math. And the idea is for attorney, a good way to ask the attorney is, okay, on a monthly basis, between now and the next 6 months, how much time do you think you're going to spend in the case? And give me an idea of the budget that I need to have in order to prepare this budget and whether or not I can afford it. And that is a good way to do it. And I'll just give you an analogy. When, I watch, my wife makes me watch HGTV. She doesn't make me watch it. I love it too. So I watch the shows with her, and I love the shows about that they have to fix problems that the homeowners created. I think one is Help I Wreck My House. It's one of the shows that I love. And the reason I like that show is about problem solving. The homeowners basically create chaos in those homes, and they try to bring, I think Jasmine is the host, to try to fix it. But one of the things that she asks is, what is the budget that you have to fix this? And that's the thing. You need a budget in order to be able to fix the house, fix the property. They're not going to do it without a budget. They're not going to do it without having the funds available. Litigation is the same way. We have to have a budget, litigation budget available to be able to help you solve your legal problem. Whether it's you're going to sue or you're going to be the one being sued, there has to be a litigation budget and to be able to help you with your legal matter. And we can talk specifically about how to finance that. I know there's some financing companies that provide financing for legal services, and we can talk more about that later in a different show. But for the most part, the topic for today is, can I afford a lawsuit? The answer is depends. In my experience, many business owners can't. So in terms of taking a case from the beginning of the case all the way to trial, it's really could be prohibitive. And it can basically bring a business down, even if you are right. Even if you have the best case possible, if you don't have the resources available to defend it, it could be a problem. So the answer to that is to triage and really use the funds effectively to have the best litigation strategy possible with the funds that you have. That is basically, in my opinion, the key here, because you're not going to be able to do everything. You got to do what is essential to help you solve this case, and you can move on. You're the one suing, do it effectively. If you're the one being sued, do it effectively. You have a certain amount of resources. Let's use them effectively. Let's do what we believe will give you the greatest result to get you out of this legal problem, because you have better things to do than be involved in a lawsuit. We do this for a living, but you don't. So the idea is for you to go on with your business and get out of this legal problem as soon as possible. So I hope this information was helpful to you. If you have any questions about this topic, please send them to me at rich@richsierra.com. I go into more detail into the cost of litigation in my book in Chapter 8, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble, and you can ask for it in local bookstores. If you want to learn more about the legal services that we offer, our website is floridasmallbusinesslegalcenter.com. You can have this podcast on YouTube, you want to watch it, we're at youtube.com/@RichardSierra. If you want to give us a call, number is 866-842-5202. If you like the podcast, hope you did, and I hope information is helpful to you. Please, like us and follow us and give us a review and share it with your friends. I think this will be helpful to them as well. We're available in Apple Podcasts, Spotify, wherever you listen to your shows. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.